Ininda testify that they obtained the statement of Mr. Sfiso Zungu, and that he's the one who told them about the presence of Constable Zungu during the incident, and not the other way around. That is the first point. We'll try and find the relevant portion of the record. Secondly, counsel is in possession of a statement made in terms of Section 204 by this witness. If the state called this witness, it would have requested that the provisions of Section 204 be explained to the witness, but that hasn't happened as yet, my lord. We just wondered, as a matter of procedure, whether if the witness is called by the defense, whether those provisions should also not be explained to the witness.
But the statement, does the statement obviously show that it is made in terms of which section?
Section 204.
It's on the...
Yes, it's
you
on
must
the
remember, I don't have the statement.
Yes,
I
it's
haven't
on the
seen it.
statement itself.
So
Yes.
it says statement in terms of Section 204.
Yes.
And then blah, blah, blah.
Yes.
Yeah, okay. Let's hear you, Mr. Mnisi.
kunamagama-ke awasebenzisayo kufakazi ukuthi-ke uphenyo lwamaphoyisa lwabaholeka-ke ku-Constable uZungu umshushisi uthi cha akukho kanjalo lokho kuyistatimende esenziwa uSifiso Zungu istatimende leso-ke esathi-ke indlela-ke leyo kwatholakala ngayo uConstable Zungu. Okwesibili-ke umshushisi utshela inkantolo ukuthi-ke ummeli unestatimende-ke esenziwa uyena-ke lo fakazi uma bekuwukuthi lo fakazi ebebizwe umbuso kunesexwayiso ebezosithola-ke ngenxa yestatimende leso asenza ukuyabuza-ke kwinkantolo ukuthi uma ufakazi lona ebizwe abameli ukuthi-ke akufanele yini leso sexwayiso leso asithole.
As it please the court, my lord. The first point relating to where the information came from about the case and involving the arrest of the accused that are before court here, my lord. The sequence is immaterial.
It's what?
From where we're standing, actually from where I am standing, because
It's immaterial.
that is my submission.
Yeah, no, I just want to hear you too.
Yes. Because, and the reason why I'm saying this, my lord, the state investigates a case. Whether they are using a particular sequence or not, I'm not privy to the methodologies that they are using in investigating a case. But all that is before court here is that there is a Constable Zungu who came to this court and gave out the information that we are busy with here. I am busy taking through this witness what Constable Zungu came and testified about in the events that happened on the 26th of October 2014. And the reason why Constable Zungu had to come to court here, come testify, it is because of the work or the investigation that was conducted by the investigating team in this case, who at one point came across Constable Zungu. I think the state is worried about the fact that I used the term stumbled. Let me say stumbled, stroke, came across a Constable Zungu who said, you know what, you probably might want this information that I have. And this is information that I have. He gave them that information. Subsequent to that information, what steps did the investigating team took for my leading of this witness here? That is immaterial. Whether they went to Mr. Zungu, the senior, or they went to somebody else, to me that is immaterial, my lord, because that is their own investigative prerogatives as to whatever that they did. But all that I'm saying is the information that Constable Zungu came to testify about here at court is an information that came about as a result of the fact that the police came across him and he said, I've got this information that can assist you. That is all that I said. So the sequence on how that information is being obtained, it is neither here nor there. That will be my argument at the end of it all. Now the second point about this witness having made a Section 204 statement, my lord. I don't know what is the state worried about there, whether he should have been warned or what. I'm in the same position as him. He's basically asking this court to come up with an answer to the objection that he's raising. He's basically saying to this court, my lord, this witness has made a Section 204 statement. I don't even know whether he made that statement. I don't even know whether that statement will be relevant in me leading that witness, my lord. But the state is saying to the court, my lord, this witness made a Section 204. And having made that Section 204, I don't know if the defense is allowed to lead him without having warned him of the provisions of Section 204. I've called a witness, my lord. The defense does not investigate on the basis that a witness is Section 204. No. The defense simply calls a witness that they would, which in their mind are saying that this witness will come and assist this court in the presentation of the defense case. Whether that is a Section 204 witness, or whether it is a Section 204, whatever witness. Now the question is, if this was a Section 204 witness, my lord, why did the state not call him? For them to come and complain thereafter that, but no, the defense cannot call this witness because he was our witness in terms of Section 204. Then they should have called him. They decided not to call him. And then you are saying, oh, that which we decided to throw away, I think it will be useful for us. Then we went to the trash place, we cleaned that witness with all the soaps and everything and say, now we are going to make you a human being. Come and testify, come and tell this court, what is it that you know about this incident? Then the state stands up and say, no, but we should have warned him. No, the defense does not call a witness on the basis that that witness is a Section 204. That's a prerogative of the state, my lord. But if they decide not to use him and discard him, we'll definitely pick him up from the trash place and come and bring him here to court to come and tell this court what is it that he knows about this case. So I find no reason for the state.
Yeah, but you guys are not addressing me in terms of the law. It's okay to talk and talk and talk and talk.
That is the state that must do that, man.
Mr. Baloyi, are you saying this witness is impeachable?
Well,
That's the legal language you must
yeah.
be addressing me on, not...
Yes, my lord, we're raising issues of procedure. There's Section 203 and Section 204, and that refers to the rights of a witness. And I think every witness needs to be apprised of such rights. It's not dependent on the witness. It's a question of procedure. Counsel has been asking a witness, for instance, whether Constable Zungu gave him a firearm, to keep it for him. I think this witness needs to know what his rights are as far as incriminating questions are concerned. And secondly, as we mentioned, my lord, that this witness doesn't just come as an ordinary witness. There's a certain status that is accorded to him, and that needs to come on record, my lord, that what type of witness he is. But regarding the first point that we raised, my lord, we differ from Advocate Mnisi with the greatest of respect. It's crucial. If he's approaching the evidence from a wrong perspective, then that goes to the heart of this witness evidence. If the evidence of Brigadier Gininda is, as we say, that his statement was obtained first, and that they learned from his statement of the involvement, of the presence of Constable Zungu, that's crucial, man. It goes to the heart of this witness evidence. It goes to his credibility. He's been saying that Constable Zungu is lying all the way, but if his evidence is approached from the correct perspective, as testified to on record, that might change the approach to the witness. That's all that we're saying, Mano, that and Advocate Mnisi says the sequence is not crucial. It is crucial because it goes to the credibility, it goes to the way that his evidence should be approached, and my colleague has just referred me to the evidence of Brigadier Gininda on the 1st of November 2024, page 25, line 2 to 9, where he says, "There are statements that are obtained. I'm just not sure if those witnesses have testified, but during the course of the investigation, before Constable Zungu's statement was obtained, there were statements obtained which linked all the accused in this offense collectively from accused 1 to 5. And those statements are in the docket. This part doesn't specifically refer to Mr. Sfiso Zungu, but we're still looking for that specific portion that wherein Brigadier Gininda testified that it is as a result of the information that was furnished by Gwabini, as is commonly known, that he then approached Constable Zungu. And as we said, my lord, without belaboring the point, that is very crucial. It is important that it should be threshed out.
Mr.
As it is the court, my lord.
Yeah.
May I request an indulgence just to say a thing or two in clarification and demystifying what is happening here, my lord. I will not repeat the first point relating to how the investigation was conducted. This court is not concerned about what processes. Actually, let me not say this court is not concerned about what processes. Whether A came before B or C came before A, with regard to the testimony that is here at court, my lord, that is immaterial. What is immaterial here at court is whether the allegations that are raised against these accused persons have got any substance. Whether in the course of investigation the state jumped from 1 to 7, from 7 to 14, that is immaterial. All what is material is the presentation that is made here at court. Now,
No, I differ with you. Let me tell you. The sequence of the occurrence
yes,
is critical,
yes, my lord.
because if you take a witness under cross-examination
Yes, my lord.
and he starts testifying about the death of Rata Mokhatlin
Yes, my lord.
without having testified how Rata was stabbed with a knife, a panga, his head was shaved off, etc., etc., etc. The judge is going to say to you, how did the assault start?
Yes, my lord.
Yeah.
Yes.
So it's material. Other counsel will argue that this witness is not reliable because he says B instead of starting at A. I don't want to put it further than that.
Yes, my lord.
Yeah. So the sequence of the evidence is material.
That is so.
It must be so.
I definitely
The
agree.
only thing
Yes.
which you guys must tell me, why don't you read 204? Because, for instance, look at section 105A, where a person wants to plead guilty, and he conducts a consultation with the state, and subsequently decides not to sign the agreement. That act of not signing that agreement nullifies that agreement. Is that not so, Mr. Baloyi?
Yes, indeed, ma'am.
Quite. Now, if a person is a 204 witness, are you saying to me there's no procedure whatsoever which is necessary to warn, as Mr. Baloyi says, the witness of his rights?
I'm just
Because
about.
in terms of section 203, our constitution debars a person from self-incrimination. Why don't you retire for, I don't know, 10 minutes, 15 minutes, an hour, research that point? I think it's critical.
May I quickly
Okay, fine.
say a thing or two?
Yeah, fine,
Malot,
fine,
before we take an adjournment. Malot. The court is mentioning that it is critical for a witness who testifies to
Sequential.
mention. Excuse me, my lord.
Sequentially.
Yes, to testify sequentially, my lord. But that is now when a witness is testifying at court. I am referring to the investigative methodologies that the state raised and said that it is not correct for the defense to suggest that the police stumbled across, upon Constable Zungu, who then implicated, and then who also mentioned the name of this witness here. That is totally different from investigation. Is totally different from when a witness is testifying, my lord. So that is basically my point. It is indeed true and correct that when a witness is testifying, they need to prefer their testimony in a logical and a sequential way. But that is totally different from the investigative techniques and methodologies that police employ in the course of investigation of their case, my lord. Hence, I say, whether I said to this witness that the police, in the course of the investigation of this case, they stumbled upon Constable Zungu, who then mentioned his name here, that is material, my lord. The fact is his name was mentioned in the course of investigation. At what point, that is immaterial. That would be my submission, my lord. Now, back to the second point, my lord. Now, the state is approaching this case as if indeed the testimony of this witness is a testimony of a section 204, my lord. Now, that is not our approach, because for a person to be warned in terms of section 204, the person must come and say, you know what, there's a little role that I played in the commission of this offense. So what is it then will come out of that when I'm going to incriminate myself at court about that information? But this is not a testimony of this witness, my lord. This testimony, this witness says no. Everything that I've that I've mentioned to him up to thus far, he says that is a lie. So what would then have been the basis for the defense to treat this witness as a section 204? Because we have consulted with him. There is nothing in our view which would have necessitated the defense to request the court to warn this witness in terms of section 204. There is nothing. What would have been the basis? I don't know. Maybe the state, they believed in the fact that that is now in their own little corner and cubicle, that Mr. Zungu, Mr. Gwabini, to us, state, is a section 204 because of this. But us having consulted with him, there are no basis at all to regard this as a
fine.
witness in terms of section 204.
So you want to proceed?
Definitely, my lord.
Yeah, but for the court me because I'm the judge. Can you take out section 203? We read it as a matter of course to Mr. Zungu.
Yes, and just apart from what council is saying regarding consultation, just on the basis of what has emerged so far, what is on record, that warning need to be administered to the witness. But before I get to the section, my lord, just again on the evidence of Brigadier Gininda, on the 1st of November 2024, page 25, the state asked him about when the statement of Constable Zungu was obtained. Then he says at line 12, Brigadier Gininda, my lord, it was obtained sometimes last year, in my recollection, the year 2023, before June. That is when it was obtained. Then he says testifies as follows at line 18. So during the course of the investigations, my lord, that is now after or during the course of the investigation of this matter, the name of Constable Zungu came up as a person who was present at the hostel on the 26th of October 2014. So it came out during the course of the investigations when I was interacting with other witnesses that I have referred to who deposed to affidavits. Subsequent to that, my lord, he was then approached because I received, I think it is more than one statement where his name kept on coming up as a person who was at the hostel on the day, my lord. When I confronted him, my lord, the report I got was that he was fearful of reprisal since he knows the accused, but also wanted us, according to what he told me, to do our own investigations without having to influence us. That is his evidence, my lord.
Yeah, fine.
And as we said, the order is crucial. Coming back to section 203, it reads follows.
Yeah, just to explain to
We-
Mr. Sorry, just to explain to Mr. Zungu that even if you are a witness for the state or you are a witness for the defense, the Constitution still protects you. And this court is not saying you must fashion your evidence in whatever manner. But in terms of our Constitution, Section 203 of the Criminal Procedure Act governs the rights of a witness in our courts. Okay.
Inkantolo mnumzana uZungu ifuna ke umnumzana uGwabini ifuna ukutshela lokho okulandelayo ngoba ke manje kunalo inkulumo ke ekhona ke phakathi kombuso kanye futhi ke nommeli umbuso usho ke ukuthi ke bekufanele ukuthi ngaphambilini kokuthi ke uqale ukuthola ubufakazi bakho wexwayisweke ngoma uma bekuwukuthi ububizwe uwona umbuso kunestatement umbuso othi wasenza ke ngokomthetho ke bakubiza ngokuthi ke leso statement wasenza ngaphansi komthetho sekelo noma ke usection 204 manje inkantolo isithi ke ayikutsheli ke noma ayithi kuwena ukuthi ubufakazi bakho busho ngayiphi indlela kodwa ke umthetho ifuna wazi ukuthi ke umthetho sisekelo ke uyakuvikela ke ufanele ke ukuthi ke sibe khona isexwayiso onikezwa sona wazi ukuthi uma wethola ubufakazi bakho kodwa wazi ukuthi sikhona ke lesixwayiso ositholile ngenxa ke yestatement lesi umbuso okhuluma ngaso abathi wasenza kubona noma emaphoyiseni.
And just before we proceed with the reading of the section, again the report, and this is the part that we're looking for, is on the 8th of November 2024, page 60, line 9, Brigadier Gininda. Yes, my lord, I think one statement that comes from the top of my mind is the one of Gwabini Sifiso Zungu. It's guided to me to that effect because he places the 5 accused, and I think he talks to that issue of contractual killing. There are other statements, my lord, which may be involving not collectively, but some of the accused, individual. For example, accused 3, 4, where almost similar assertions are made. So there are different statements in the docket, and I can be specific if that is needed. But one of them, like I said, it is Sifiso Zungu. And this was in response to the question by Mr. Ramusepeli. And the preceding question was Mr. Ramusepeli, line 2. And then you also mentioned that the investigation which resulted in evidence under oath revealed that the victim was murdered as a contractual assassination or hit rather than a robbery or robbery gone wrong. Can you elaborate on that, and what statements and evidence did you rely on to come to make such an assertion? That's when he refers to the statement of Mr. Gwabini Zungu.
Umbuso lana ke ufunda ke kule ndawo ke bethi ke kade beyifuna ke ukuthi ke nanjengoba ebeshilo ke ukuthi ke umnumzana Mnisi ke utheni kuma ekhuluma kufakazi ngokuthi ke kwatholakala kanjani ukuthi ke amaphoyisa akhulume naye ke uConstable Zungu. Lana ke uGininda ekubufakazi bange 8 zika November 2024 uthi ke yebo inkosi enkantolo ngicabanga ukuthi ke esinye istatement ke engisikhumbulayo ke istatement sakhe uGwabini uSifiso Zungu isona ke esangiholela kuloko ngoba ke uyabachaza noma uyabasho bobahlanu ke abasolwa engicabanga futhi ukuthi ke ukhuluma ngalo udaba ke lokubulawa kwakhe ke umufi zikhona ke nezinye istatement enkosi enkantolo la abahlangana noma ke ezibahlanganisayo ke ndawonye bebonke kodwa ke abanye babasolwa umuntu ngayedwa la khulunywa khona ke ngomsolo wesithathu kanye nowesine la ekukhulunywa khona ke noma kushiwa khona ke into efanayo kodwa ke ikhona ke istatement ezahlukahlukene kulona ke idokodo kodwa ke ngasho ke inkosi enkantolo uma lokho ke kusikhona ke isidingo kodwa ke esinye saso ngicabanga ukuthi ke nanjengoba ngishilo ke isona ke esikasifiso Zungu aqhubekeke umshushisi athi ke leyo mpendulo leyo ke yayibuya kuwona umbuzo wakhe umnumzane uRamusipile ushilo ke ukuthi kwakulona umbuzo kaMnumzane uRamusipile ushilo ukuthi uphenyo ke lwaholela ke kubufakazi lobu obushoke ufundile ukuthi ke isisulu ke sabulawa nokuthi ke futhi ke akusona ke ukuthi kwakuyobanjwa inkunzi kodwa ke umuntu lowo ke wabulawa ungachaza ke noma usho ukuthi ke yiziphi istatement noma ubufakazi owawunabo noma onabo ukuze ke usho lokho wase enikeza ke lempendulo uBrigadier Kenini.
Yeah, as Madam was saying, as a starting point, is the status of this witness should have been clarified. We're going to read section 203 into the record. The heading is witness excused from answering incriminating questions. No witness in criminal proceedings shall, except as provided by this act or any other law, be compelled to answer any questions which he would not, on the 30th day of May 1961, have been compelled to answer, by reason that the answer may expose him to a criminal charge. Then section 2.4, incriminating evidence by witness for the prosecution. As I said, this section specifically refers to the prosecution. It says, whenever the prosecutor at criminal proceedings informs the court that any person called as a witness on behalf of the prosecution will be required by the prosecution to answer questions which may incriminate such witness with regard to an offense specified by the prosecutor. A, the court, if satisfied that such witness is otherwise a competent witness for the prosecution, shall inform such witness, Roman figure 1, that he is obliged to give evidence at the proceedings in question, Roman figure 2, that questions may be put to him which may incriminate him with regard to the offense specified by the prosecutor, Roman figure 3, that he will be obliged to answer any question put to him, whether by the prosecution, the accused, or the court, notwithstanding that the answer may incriminate him with regard to the offense so specified, or with regard to any offense in respect of which a verdict of guilty will be competent upon a charge relating to the offense so specified. So this subsection A, Roman figure 3, refers to the obligation to answer any questions put to him, whether by the prosecution, the accused, or the court. And Roman figure 4, that if he answers frankly and honestly all questions put to him, he shall be discharged from the prosecution with regard to the offense so specified, and with regard to any offense in respect of which a verdict of guilty would be competent upon a charge relating to the offense so specified. And Roman figure B, such witness shall thereupon give evidence and answer any questions put to him, whether by the prosecution, the accused, or the court, notwithstanding that the reply thereto may incriminate him with regard to the offense so specified by the prosecutor, or with regard to any offense in respect of which a verdict of guilty would be competent upon a charge relating to the offense so specified. So once again, my lord, subsection B refers to the obligation of a witness to answer questions put to him, whether by the prosecution, the accused, or the court.
Now,
And-
that's applicable if it's,
Yes.
the witness is called in terms of section 204.
Yes, yes,
So it's not applicable.
yes.
In my view, what is applicable is just to warn the witness against self-incriminating.
yes,
But I'm not stopping him from answering the question as he deems fit.
yes,
But my duty as the judge,
yes.
I'm obliged to point out that limitation.
Yes, indeed, and we're raising this as a
Yeah.
procedural aspect.
That's it, yeah.
Because it might impact on the fairness of the
Yeah, quite,
trial.
yeah.
Yes.
Because in the past, before the Constitution came into being, there was no obligation on the court to do so. If a
Yes.
witness comes, gives evidence, perjures himself, the prosecution can do whatever it deems meet. You know, the old section 205, when the Criminal Procedure Act was not yet amended, there was the Terrorism Act. Section 6 of the Terrorism Act used to say that a witness or a person can be detained by the South African police, primarily, obviously, the security branch. And such detention can endure for about 90 days, and no lawyer, doctor, or priest may inquire after the health of the said witness. But since the Constitution overrode all these sections, even security sections, by saying that within 48 hours you should be charged, irrespective of whichever charge you are facing. But still, the Constitution says a person must be apprised of his rights. So that's all I'm saying to this witness.
And that's also all that we are asking.
Yeah, no, fine. Yes, Mr. Mnisi.
Ekushoyo kwenu inkantolo mnumzana uZungu ethi nje ifanele ukwazi ngoba ke umthetho uthi ke inkantolo inkosi enkantolo ifanele ukwenze lokho ukuthi nje kunemibuzo ozoyibuzwa ke kungaba yimibuzo engathi wena ke uyambandakanyeka noma uyingxenye yento yenziwe inkantolo kufanele nje yena ikunikeze isexwayiso ukuthi ke awuphoqelekileke ukuthi ke imibuzo enjalo ungayiphendula ithi kuumsebenzi wayo lo ukuthi kufanele ikwenze lokho ikunikeze leso sixwayiso leso wazi uma uphendula ke ukuthi uphendula kanjani.
As it please the court,
Yes, sir.
I think the state is presupposing that there will be questions under cross-examination that the state would have to put to this witness that would basically incriminate this witness. We don't know if the state would actually do that, but we have called to this witness, I've called to this witness to come and testify about the events relating to the 26th of October 2014. Up to this point, he's saying that's a lie. We don't know whether we'll come to a point where he says, yeah, no, that one is not a lie.
Now he's entitled to answer any way if he wishes.
As it pleases the court, madam. And in fact,
I see, Mr. Umar, you want to say something? Hello? Am I correct when I say a witness can answer the question any old way he or she chooses?
He can answer in any way that he wants to answer.
Hello?
He can answer in any way that he wants to answer.
Yeah, they say there's freedom of speech. Mr. Mnisi started by saying there's freedom of speech in South Africa and freedom of what?
expression.
Expression.
Yes.
One day I will tell you why this judge was saying whatever he said in the past.
As it pleases the court.
Yes, let's proceed then.
Thank you, Mr. Zungu. Mr. Gwabini.
Where is he? Is he seated now?
Yes, Madam, please.
Okay, you can sit if you're not as fit as I am.
Ungahlala-ke mhlengikazi ukuthi uma ungekho fit ngale ndlela engifit ngayo ungahlala phansi.
Thank you, Mr. Gwabini. Now, the last point that we dealt with before the short adjournment was about the fact that Zungu, the constable, requested you to give him back his firearm. That's not what he said. He said that he inquired about his firearm from you, and then you gave it back to him, and then he released the magazine thereof.
La egcine khona ke la bengithi kuwena ke uZungu kubufakazi bakhe abethula la enkantolo ukuthi ke wase ecela wena ke ukuthi ke umlethele isibhamu sakhe ke wase ke ekhipha ke lokho ekula ngasemuva ke kusona isibhamu okubizwa ngokuthi ke imagazine.
Do you still remember that?
Usakhumbula lokho? No, he's telling lies.
Thank you. Now, he proceeded. This is Constable Zungu telling this court what happened on the 26th of October 2014. He proceeded to say that the firearm that he requested you to give it back to him, which was his firearm, was a 9mm Z88 pistol.
Kubufakazi bakhe abethuleke enkantolo ushilo ukuthi isibhamu leso ke acela ukuthi umnikeze sona kwakuyisibhamu sakhe kwakuyi 9mm Z88.
Awunamanga.
No, he's telling lies.
Thank you. Now he proceeded to tell this court that after you gave him the firearm, and then he took the magazine from that firearm, which was a 9mm Z88 pistol, and then he smelled the barrel of the firearm because, and the reason why he did that, it's because he suspected that something was very suspicious in that room.
Uthi ke emuva kokuthi usomnikele isibhamu eseyichiphileke imagazine wasesithatha ke isibhamu la ngaphambili ke kusona isibhamu kuloko kubizwa ngokuthi ke ibarrel la ngaphambili isibhamini wasesinuka ke isibhamu ngoba ke ethi ke kuyena ke kukhona nje kwakusolisa noma kwakusolakala kuleli yagumbi leliyana.
Unamanga.
This person is telling lies.
Thank you. Now he proceeded to tell this court that whilst in that very same room, he also took the .38 special revolver from Mnisi and looked at it.
Uthi ke nise lapho nje wasethatha ke i.38 special yana eyayiphethwe uyena uMuzi wase eyibheka.
Khuluma manga.
Telling lies.
He further told this court that his observation of what was happening in that room was that those firearms that were in possession of accused number 1 and accused number 3, now the .38 revolver and the 9mm pistol, were firearms that had to be handed to you.
Uthi ke kuloko akubona ke kwakwenzeka ke lapha yana lezi ibhamu lezi yana ezimbili ke lesi sasiphethwe uMuzi i.38 special i-revolver kanye ke ne-9mm ephethwe umsola wesithathu kwakuyibhamu kwakufanele ukuthi indluliselwe kuwena bayithathe njengoba iphethwe yibona bona base beyayithatha bayinikeza wena.
uqamba amanga.
telling lies.
Thank you. And then he further told this court that in that hit or at that moment, he then inquired from you, or he asked you as to why is it that you are still in possession of that .38 revolver, as according to him he knew that it was lost.
Uthi ke wasekubuza wena ke ukuthi kwakungani usenaso leso sibhamu leso ke i.38 ngoba ke ngokusho kwakho wena isibhamu leso ke sasidukile.
Ayunamanga.
He's telling lies.
Then he proceeded to tell this court that your response to him, to the question that he asked you, you said to him, no, don't worry, that is not the same firearm. That was not the same firearm.
Wasuphendula ke wena kuloyo mbuzo wathi cha hayi ungakhathazeki ke akusona lesi sibhamu leso okhuluma ngaso wena lesi.
Ayunamanga.
He's telling lies.
As a court, please, I know counsel is summarizing the evidence, but the evidence is that Constable Zungu asked Gwabini if it's not the same .38 special that was used to shoot Snako, and the response was that it was thrown in the river, not that it was lost.
Yes.
Yeah, I'm sorry. Even though it is my colleague's advocate, Mnisi's, it is my colleague's advocate, Mnisi's chance to lead the witness. But my colleague advocate Baloyi is also getting it wrong. The issue of Snako is mentioned in the statement of Constable Zungu, Exhibit AA. It was never mentioned in the evidence in chief of Constable Zungu. So my colleague advocate Mnisi.
But was it traversed?
It was traversed.
And there was an answer to that.
My lord,
Hello, wait, don't be in a hurry. Was that information which was contained in the statement of Zungu traversed by the defense?
it was traversed by the defense.
And he responded.
Yes, he responded.
And that response formed part of the proceedings in this case.
Yes.
So what's the problem?
No, the problem is my colleague advocate Mnisi is taking the witness through the evidence of Zungu, the evidence in chief of Zungu, which Constable Zungu did not mention the issue of Snako in his evidence in chief. He mentioned, as my colleague is stating. Now Advocate Baloyi is raising the issue of Snako, which was not raised by Constable Zungu in his evidence in chief. That is my
Does he have to
understanding.
Yeah, fine. It's a minor point. Does he have to raise it in evidence in chief, or raise it in his evidence, which can either be in chief or re-examination?
My lord, may I be clear on this? My colleague Advocate Mnisi is taking the witness through the evidence in chief of Constable Zungu.
Yeah, okay, fine. I thought evidence is evidence. Whether it was traversed in chief or in cross-examination or in re-examination, it's evidence. That's how I see it.
And I believe that my colleague is still going to the issue of Snako. So for this
Oh, is he still
state
going
to
there?
raise, yeah, he's still going
I don't
there.
know.
As to
I
when
don't
it
know.
was raised, I think it's immaterial. But what I'm saying, as of now, my colleague is leading the witness about the evidence of Zungu in chief when he was being led by the state.
Yeah, okay, yes, let's go on. Whew.
I'm not so sure, my lord, if the state has got a response, an answer to my colleague's response.
Well, I cannot remember specifically whether counsel qualified that he's referring to his evidence in chief, but it is important to refer to the totality of a witness evidence, and that is a crucial aspect. One cannot say, this is what he said at this point, and this is what you refer to the totality of the evidence. And if we look at the record, the 8th of September 2023, page 45, in cross-examination by Mr. Ramosipile, that's what the witness said, that he says, I then took the .38 special firearm from Gwabini's hand and looked at it. asked Gwabini if it was not the same firearm which he said he threw away in the river after shooting Snako with it. And that's all that we say, Manoj, that it's crucial that the evidence, the totality of the evidence be put to the witness so that he can comment appropriately.
Yeah, okay, fine.
As it please the court, members. Thank you, Mr. Gwabini. I am told I'm cutting corners, so I won't do that. I thought that was not my approach, but apparently, according to the state, when Mr. Zungu, the constable, asked you about that .38 special, he asked you as to would this be the same firearm? Is this not the same firearm that you used, that was used in the shooting of Sinako? Because then you told him that the firearm that was used in the shooting of Sinako was thrown in the river. It went away in the river. Did that happen on 26th of October 2014?
Lana ke umbuso uyangilungisanga noma ke uyangitshela ukuthi cha angikusho ngendlela noma angikusho kahle ke ngoba bathi ke kubufakazi uma befunda phansi ke ubufakazi bakhe noma into yashiwo kuZungu noma akubuza yona uConstable Zungu ke manje ukuthi ke Gwabini ingabe le .38 special revolver akusiyona yini le eyasetshenziswa ukudubula uSinako.
uqamba amanga.
He's telling lies.
What do you know about this Sinako thing now that the state has introduced it?
Na njengoba manje ke umbuso ke usuze nayo ke le ndaba kaSinako wazini ke ngodaba lukaSinako.
Or do you know anything about this Sinako thing, if I were to put it that way?
Noma mhlambe kukhona yini okwaziyo ngoSinako wena?
Akukho engikwaziyo ngoSinako.
There's nothing that I know about Sinako.
Thank you. Now, this is Constable Zungu saying in his oral testimony here at court that when he got into your room where you were with some of these accused here, then some of these accused then started to talk amongst themselves in Zulu, saying, here is that uncle.
Uthi ke kathi ke nami kulelo gumbi lelo ke wena ke kanye nabanye ke balabasolwa ke base besho ke ngesiZulu ke ukuthi ke nangu ke umalume noma lo yamalume.
Hayi khuluma amanga.
No, we told lies.
Thank you. Then he further told this court that when he was having this little discussion with you about the firearm, which could not have been the firearm that was used in the shooting of Sinako, that .38 special that you said he threw in the river, then he said it was at that moment that then accused number 2 went out of the room where you were.
Uthi ke kuleso sikhathi leso ke ekubuza kona ke ngodaba lukaSinako ukuthi akusona yini isibhamu lesi esasetshenziswa ukudubula uSinako. Uthi ngaleso sikhathi leso ke la umsolo wesibili waphuma ke la enani khona.
Hayi khuluma amanga.
Oh, he's telling lies.
Thank you. Then he says that he further asked you as to why were you carrying firearms.
Uthi waseqhubeka ke kubuza ukuthi kwakungani uphethe ibhamu.
Uqamba amanga.
He's telling lies.
And then your response to his question was, uncle, and I am putting this in parentheses because this is what is written in the record. Uncle, I also told you to place your firearm here because I did not want all of you to be in possession of firearms.
Uthi ke wase kuphendula ke wena ke uthi ke malume nawe ke ngithe kuwena ke isibhamu sakho sibeke la ngoba ke ngingafuni ke ukuthi ke niphathe ibhamu nina.
Hayi unamanga.
No, he's telling lies.
Thank you. Then he further told this court that in the heat of that little discussion about the carrying of firearms. Then he told this court that he had the door of that very same room where you were opening behind him, and as he looked around, then accused number 5 got into that room as well.
Uthi ke kuselapho ke wezwa ke isicabha salo igumbi lelo elanikulona ke sivuleka uma ke esebheka ngasemuva ke ila abona khona umsolo wesihlanu engena.
awuqamba amanga.
No, he was telling lies.
He says when accused number 5 got into that room, he was wearing a black jacket.
Uthi uma engena ke lapho wayegqoke ijacket emnyama ngombala.
awunamanga.
Now he's telling lies.
He further told this court that when accused number 5 got into that room, he was now in the company of accused number 4, Mr. Mapisa.
Uthi ke uma engena lapho umsolo wesihlanu wangena ehamba naye umsolo wesine uMaphisa.
awunamanga.
No, telling lies.
Yes, and remember here, we are on the 26th of October 2014, according to Zungu, Constable Zungu. We are at the hostel where you had initially requested him to come visit you.
Ukhumbuleke kuloko esikushoyo noma lokho engikubuza ngako lana ke ngobufakazi bakhe uConstable Zungu kwakunge 26 zika October 2014 ehostel ilanga wena ke owathi ke na ke aze kuwena ngalo.
Do you understand?
Kezwakala. Yes, I understand.
Thank you. Now, he further told this court that having entered with accused number 4, then accused number 5 asked you if there was a problem in that room, and your response was no, there was no problem.
Uthi ke esengenile ke lapho umsolo wesihlanu ehamba naye ke owesine wasebuza kuwena ke owesihlanu ukuthi ke ingabe khona yini noma yayikhona yini inkinga lapho kulelo gumbi lelo wena wathi cha.
awukhuluma amanga.
No, he told lies.
Thank you. He further told this court that soon after you had told him that there was no problem in that room, then you then requested him to give you a space so that you could continue to speak in privately with the other people who were in the room.
Uthi ke usuphenduleke wena washo ukuthi cha bangenankinga wase umcela ke yena ukuthi ke anidedeleke nokuthi ke noma aphumeke ukuthi ke uzokwazi ke ukuthi ukhulumisane nabanye abalisa lapho.
awunamanga.
No, he was lying.
And told this court that indeed he obliged, gave you a space to continue talking to the other people that you said wanted to talk to.
Uthi ngempela ke wenza kanjalo waphuma ke ukuthi ke uqhubekeke wena ukuthi ke ukhulume nabanye.
awukhuluma amanga.
No, he told lies.
Then he went on to tell this court that as he went out of that room, he saw accused number 2, that is now Mr. Mtanzi. He was standing at some little corner there. He did not specify what corner was it, but he said, I saw him standing at some corner there.
Uthi ke esephuma ke lapho ila abona khona ke umsolo wesibili uNtanzi ke ukhona nje ikhona thizini ayeme kulona.
awuqamba amanga.
I told lies.
Well, in totality, he, in relation to his observation of him saying he saw accused number 2 standing at some corner there, he also said that he observed or noticed that accused number 2 had changed his jacket from grey to black.
Uthi ke kokunye akubona ke kuloko ukuthi wabona umsolo wesibili wasebona ke ukuthi manje wayeseshintshile ke lokho ayegqokile umsolo wesibili wayeseshintshe ijacket ke noma itop ayegqokile wayegqoke egrey wayesegqoke manje kayishintsha yabamnyama.
unamanga.
He's lying.
Now, he further told this court that then accused number 2 passed him where he was standing, that is now outside the room where he initially was, and now accused number 2 passed him along the way and he got into the same room.
uthi ke umsolo wesibili kula ayime khona ke wasendlula edlula la uZungu aye khona naye umsolo wesibili wayongena khona lapha ke kuleya room leya noma igumbi leliyana.
Aqamba amanga.
He's telling lies.
Thank you. Now, he further proceeded to tell this court that he does not know what the discussion was in that room, but then he then continued to sit in the main in the main room with these other people who were already there, whilst you guys were in the bedroom.
Uthi ke akazi ukuthi kwakhulunywani ke lapha kodwa waqhubeka ke wahlala ke nabanye ngala kathi ke nina ke nani ngale ekamereni.
Awunamanga.
No, he's telling lies.
Now, he further went on to tell this court that when they came out of that bedroom, in other words, yourself and some of the accused who were now in the bedroom, that is now accused number 1, number 2, number 3, and number 4, and number 5. You then apologized to him for having requested him to give you privacy.
Uthi ke seniphumile ke lapho wena umsolo wokuqala owesibili owesithathu owesine kanye nowesihlanu wena ke wase uxolisa ke kuyena ngokuthi ke ucele ukuthi ke anidedeleke noma aphume la enani khona.
Awunamanga.
No, he's telling lies.
He went on to tell this court that a moment thereafter, he had a discussion, you actually yourself had a discussion with him where you requested him to give accused number 1 a ride or a lift when time would come for you to leave.
Uthi ke wase wena ke umcela noma ukhuluma naye ke uthi ke ucela ukuthi ke uma esehamba noma makufika isikhathi sokuthi ahambe ke ukuthi ke agibeze umsolo wokuqala noma ke ahambe naye umsolo wokuqala.
Awunamanga.
No, he's telling lies.
Now, he further told this court that he inquired from you as to the whereabouts of Makosonke.
Uthi wase ekubuza ke yena ubuza wena ukuthi ke ukuphi uMakhosonke.
And you then started to call around for Makosonke.
Wase wena ke manje usiyafunisa ke noma ufunisa ngaye uMakhosonke.
Awungiqambela amanga.
No, he's telling lies about me.
Thank you. Then he further told the court that at that moment when he was speaking you about, when he was talking to you about the whereabouts of Makosonke, accused number 1 also came into the, went to the place where you were with Constable Zungu, and also requested Constable Zungu not to leave him behind when it was time for them to leave.
Uthi ke la enani khona ke la usafunisa kufuna ngayo uMakhosonke umsolo wokuqala waseza ke naye lapho wakhuluma naye Constable Zungu emcela ukuthi uma sekufike isikhathi sokuthi ahambe angamshiyi.
Awunamanga.
He's telling lies.
Thank you. Now, Constable Zungu told the court that you told accused number 1 that no, they will not leave him because they were still waiting for Makosonke.
Uthi wase wena ke utshela ke umsolo wokuqala ukuthi cha angeke bakushiye ngoba ke basalinde uMakhosonke noma ke usalinde uMakhosonke.
Awukhuluma amanga.
No, he told lies.
He further told this court that you again called Makosonke on a phone who he eventually arrived.
Uthi ke uphindileke wena ke wasishayela yena ke uMakhosonke ucingo egcineni ke wase efika uMakhosonke.
Abangiqambela amanga.
He's telling lies about me.
Thank you. And then he further told this court that about Makosonke, you told him that Makosonke will no longer be living with him, but he will be staying behind.
Uqhubekekile ke wathi wena ke wase umtshela ke ukuthi uMakhosonke wayezosala ke wayengazo ukuhamba naye wayezosala emuva.
Hayi umqambela amanga.
No, he's telling lies about me.
Thank you. Now, he further told this court that whilst everybody was standing there, it doesn't come out clear from his evidence as to where, but I assume it was in the common place, because everybody came out from your room. Then this is what he told this court. He told to this court that he saw accused number one taking out his red t-shirt and held a bottle of beer on the other hand and said that, and asked if you people have heard that Senzo is no more.
Uthi ke nisamileke lapho wase ekufake isikipa sakhe ke esibomvu noma i-t-shirt lakhe ke elibomvu kanye ke futhi nebhodlela lakhe lebiya umsolo woqala wase ebuza kunina ke ababe lapho ukuthi senzwile na noma senzwile yini na ukuthi uSenzo akasekho noma uSenzo seshonile.
Ayunamanga.
Eish, hayi, he's telling lies.
Ayunamanga.
He's lying.
Mr. Gwabini, I see you shaking your head in desperation. What are you? Are you tired?
Ukahle ukhathele baba uthi ngiyakubona nje ukuthi ukahle noma usukhathele.
Cha lamanga ngiqeda amandla nje hle hle.
No,
Lana
it's just,
khulunywa la.
these lies that are being spoken here, they are just draining me.
Just explain yourself. These lies that are being spoken here are just draining me. What do you mean by that?
Usho ukuthini uma uthi lamanga akhulunywa la angiqeda amandla usho ukuthini ngalokho?
Lana khunywa positive Zungu.
The ones that are being told by Constable Zungu,
Are they the ones that are draining you?
iwona aqeda amandla. Yes.
Thank you. We understand how you could be feeling about them, but please try to assist the cause the best way in which you can, amongst others, by trying to raise your voice.
Bona ke lokho ukuthi ke lamanga lana aqeda amandla kodwa zama ke ukuthi ulekelele inkantolo okokunye kwalokho ke ngithi uzama ke ukuthi nje ukhulumele phezulu.
Do you understand?
Okay.
Yebo.
Yes.
Yes. Then Constable Zungu further told this court that after accused number one had said whatever he said about them having, about you people having heard about the death of Meyiwa, then he himself, Constable Zungu, said to accuse number one that now that cannot be correct. It means your sources are providing you with incorrect information.
Uthi ke kwabe kusiba uyena ke yena Constable Zungu ophendulayo ke kuloko kwabuzwa uyena umsolo woqala wathi cha imithombo yakho ke cha ayitsheli kona ke noma la uthatha khona ke noma lo ukuzwa khona ke lokho cha awuzwanga kahle ke akusilona iqiniso lolushoyo.
Awunamanga.
No, he's telling lies.
Thank you. Now, he further told this court that after this incident that involved accused number one having asked people about whether they've heard about the death of Senzo, he then went out to his vehicles. However, he realized that his keys, that the keys of his vehicle were not there.
Uthi ke emuva kwalokho wase ephuma ke yena eya emotweni yakhe kodwa ke mayifika emotweni yakhe la athola khona ukuthi ikhiye zemoto wayengayiphethe noma zazingekho kuyena.
And then he came back to you and asked you about the whereabouts of his keys.
Wabuyela kuwena ekubuza ukuthi ikhiye zazikuphi nendawo.
Awunamanga.
He's telling lies.
Thank you. And then he told this court that you yourself then took out a phone and called someone, but then you kept on saying that, hey, these people do not answer their phone.
uthi kwaba wena-ke owakhipha-ke umakhalekhukhwini wakho kwanomuntu-ke omshayela ucingo-ke kwaba wena futhi-ke othi cha labantu laba-ke abaphendula umakhalekhukhwini babo.
Ngiqambela ma.
He's telling lies about me.
And then he further told this court that in an endeavor to try and find out where the keys were, you then left him next to his vehicle and got back into the hostel, and you then spoke to someone who, according to him, could have been related to accused number 4.
Uthi-ke kwabe sewukuthi wena-ke uyamshiya la ayekhona-ke eduze kwemoto yakhe wabuyela ngaphakathi-ke uma ubuyela ngaphakathi-ke kunomuntu owakhulumisana naye-ke uthi ngokusho kwakhe-ke loyo muntu lowo kwakuwumuntu-ke oyisihlobo noma-ke ohlobene naye umsola wesine.
Awunamanga.
He's telling lies.
Thank you. Then he further told this court that you kept on saying to him, hey, there's a person that was called Mzala that you were trying to call, but he was not answering his phone.
Nokuthi wena wabusumtshela-ke ukuthi kunomuntu-ke enanimbiza noma-ke owayebizwa ngokuthi umzala nokuthi-ke loyo muntu loyo-ke wayengaliphenduli ucingo lwakhe.
Uqamba ma.
He's telling lies.
Thank you. Then he then told this court further then that eventually accused number 4 then arrived and took out keys from him and gave them back to Constable Zungu, and those were Constable Zungu vehicle keys.
Uthi-ke ekugcineni-ke kwasekufika yena-ke umtholo wesine wakhipha-ke iy'khiya kuyena-ke wamnikeza-ke uthi lezo y'khiya lezo kwakuyiy'khiya zemoto yakhe uZungu.
Awunamanga.
He's telling lies.
And then as he was preparing to leave, or just before he could leave, you told him, that is yourself, you told him that no, Makosonke would no longer be living with him.
Uthi nje ngaphambi kokuthi ahambe-ke kwabe sekuba uwena-ke omtshelayo ukuthi cha uMakhosonke akasahambi nawe.
Ngiqambela ma.
He's telling lies about me.
Thank you. He told him, he further told this court that because Makosonke was no longer available to live with him, then he ultimately left with accused number 1 and accused number 4 and 2 other people who he did not mention by their names.
Uthi-ke ngoba-ke uMakhosonke wayengasahambi naye-ke wase ehamba nomsolo wokuqala owesine kanye nabanye ababili angabazi amagama abo.
Uqamba ma.
He's telling lies.
Thank you. My Lord, I realize that it is already 2 minutes past 1 o'clock. May I request for a lunch adjournment, my Lord?
Yeah, 2 o'clock then.